Major breaking news out of the United States Court of Appeals for the Fourth Circuit in Richmond, Virginia, covering Maryland as well. A major argument took place in front of a 3-judge panel involving whether or not 18, 19, and 20-year-olds can acquire firearms, specifically handguns, from FFLs, which currently they are banned by federal law from doing so. This was a big argument in front of 2 anti-gun judges and 1 normal judge. And let me just say, when we break this down, when we come right on back, that panel, let me be clear, at least with respect to 2 of the judges, they are legends in their own minds. Let's talk about what that means when we get right back. Hey folks, I'm Mark Smith, host of the 4 Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in the 2025 Gun News Awards. Thank you for your support. That is a great honor to be the top voice of the Second Amendment in America today. I really do appreciate it, and I hope to continue to earn your trust here at the 4 Diner and beyond. All right, folks, this is a big deal today. We had a huge argument in the U.S. Court of Appeals for the Fourth Circuit out of Virginia and Maryland. This was a terrible 3-judge panel. Although there was 1 judge that's winnable. The other 2 are unwinnable, specifically Judge Harvey Wilkinson, who you know is literally competes for America's worst gun judge, the worst anti-gun judge in America. This is the same judge that I played tapes of him before, where he literally says that you can explode and destroy a body with a machine gun, based on his experience back in the 1960s with M16s, supposedly. Literally, that's how bad this judge is, Judge Harvey Wilkinson. He used to be a feeder judge of the U.S. Supreme Court. He was quite respected. I don't think he is where he used to be. He is not the same judge as he was 20 years ago. That's just the way it is. Then you also had a second judge there, Toby Heitens, a very smart judge, but a Joe Biden judge. No way to win him. So basically, this is a 3-judge panel. There is no way to win this case. We're going to lose this case almost certainly 2-1. The third judge is a very respected judge. Winnable judge, not particularly offensive to anybody, and doesn't have the same sort of partisan appeal that the other 2 judges have, in my opinion. Now, nevertheless, let's talk about this argument. And remember, the good news is that whichever way the Fourth Circuit goes, we've actually already won this argument in the U.S. Court of Appeals in the Reese versus ATF case involving the exact same federal law dealing with whether or not 18, 19, and 20-year-olds can acquire firearms from federal firearms licensees, or FFLs, i.e. can you buy a gun from a gun store? Specifically, handguns is what we're talking about here, because federal law bans 18, 19, and 20-year-olds from being able to buy handguns from FFLs and gun stores, which is kind of absurd. So they can buy guns out of a buddy's trunk in a private transfer, but they can't acquire guns from an FFL. You tell me how that makes sense. Nevertheless, let's carry on. So what did this panel say? Again, we know we're going to lose this case. The only question is, how will we lose and how fast will we lose? But again, the good news is we actually have already won this issue in the U.S. Court of Appeals for the Fifth Circuit in the Reese versus ATF case, which I'd previously predicted. So we're going to have a clear shot to the U.S. Supreme Court if the Trump administration decides to seek cert. There's a bunch of strategy calls associated with that. We'll get into that in a separate video. But for today, I just want to cover the news associated with this oral argument in the Brown versus ATF case. Specifically, Judge Wilkinson basically kept referring to this ban on acquiring firearms for 18, 19, and 20-year-olds as a modest restriction and kept saying, why can't you just wait till you're 21? Now, this is so absurd because why can't you just wait until you're 21 to vote? Well, you have the 26th Amendment. Why can't you just wait until you're 21 to get married? Why can't you wait until you're 21 to enter into contracts? Why can't you wait until you're 21 to go join the army? Why can't you wait until you're 21 to get an abortion? Why can't you wait until you're 21 to change your sex or to get a tattoo, and so on and so on and so on? And nevertheless, this is exactly what Judge Wilkinson was asking. Why don't you just wait till you're 21? But of course, that's absurd because the same exact people that are just starting out in life, many of whom don't have 2 nickels to rub together because they're just starting their life. Like everyone in America, I know I was poor at 18, 19, and 20. I was had no money to speak of, really. So with that said, those are the people in many instances need the firearms to defend themselves. themselves because they're out on their own. They're in their own apartments. They're sharing rooms, whatever it is. They got the worst shift at the power plant. They got the worst shift at the hospital because they're the low person on the totem pole. And here you have Judge Wilkinson saying, just wait until you're 21 to get a gun. But of course, that's not how the Constitution works, because the reality is, if you look at the text of the Constitution, there are age restrictions where you cannot maybe be a member of Congress until you're 25. You can't run for the White House until you're much older, right? There's specific rules in the Constitution where the Founding Fathers wanted to restrict your ability to participate in our system of government, in our society in some way. But those age restrictions we see in other parts of the Constitution are absolutely not there in the text of the Second Amendment, nor are they in the text of the Bill of Rights. And that is a critical point that seems to be lost on anti-gun Judge Harvey Wilkinson of the Fourth Circuit Court of Appeals. Then Judge Wilkinson asked a lot of questions about Heller's dictum. And this is quite interesting. He tries to be cute and clever. He says, well, if you look at Heller said nothing about the Supreme Court decision, and Heller specifically is designed to implicate the conditions of sale of firearms, like nothing about this case. But of course, that's absurd. That may be true with respect to Heller, but if there's a restriction on acquiring firearms, that does indeed implicate the text of the Second Amendment, because the right of the people to keep and bear arms presupposes you can actually get a firearm, you can actually acquire an arm, because last I checked, we're not born with guns in our hands. It's not part of us. So the only way we can either get a gun to keep, which means to possess, or to get a gun to carry, which is the same as to bear, right? We have to be able to acquire it. And the way you acquire arms, obviously, most people, when they want to acquire stuff, they buy it from stores. So you would buy a gun from a gun store. Yeah, there may be other ways. You can make your own gun. You can maybe, get it, from a buddy. You can inherit it. Yeah, there's other ways of getting guns in addition, but the most prominent way, one buys eggs, one buys a car, one buys lights, one buys furniture, one buys guns, is you go to a store and you buy it. And yet 18, 19, and 20-year-olds under this federal law are denied the ability to go to a gun store and acquire handguns, the most popular weapon in American life. Far more popular than rifles, even the AR-15. We're talking about handguns here. They're not allowed to buy under federal law from an FFL. Then, of course, they talked about the Militia Act of 1792, discussing why is this even matter. But again, we understand why it matters, because the Militia Act set a standard for the country in 1792, less than a year after the adoption and effectuation of the Second Amendment. And the Militia Act of 1792 was a national standard that set the age of 18 as to when you were mature enough to be in the militia, and you also have the obligation to acquire your own firearms and your own ammo and your own pouches and your own black powder at the age of 18. That is the date in which you became a full-blown adult when it came to firearms, and that was a national standard. It also discussed in this case was a discussion of Henry Knox and George Washington, who discussed the proper age of the militia. They literally had this conversation, and it was their view, including General George Washington, our first president, founder of the country. George Washington thought that any age under the age of 18 was too tender of an age for someone to be able to fight in the militia, and thus the Militia Act of 1792 said 18 years to 45 years, and this is mission-critical historical data that the anti-gunners and the Department of Justice, I don't see how they overcome, as we saw in the Reese case in the Fifth Circuit. But I can assure you that these judges in the Fourth Circuit are going to find a way to rule against the Second Amendment, whether it's based in the law or not. And I want to be clear, listening to this oral argument, it is clear that both Judge Toby Heitens as well as Judge Harvey Wilkinson, these are two judges who clearly are legends in their own mind. They clearly think they're the smartest people in the room. They think they're intellectual giants. They think they should be the head of the bar associations. They think they should be on the Supreme Court. They definitely want to be given all the great speeches across the country about American law and jurisprudence. Ha, 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 ha. The good news is Judge Wilkinson never got on the Supreme Court. Thank you, God. And given the fact that Donald Trump just won the election, Toby Heitens will likely not be on the Supreme Court either, because he's probably going to age out. But one never knows, of course. So the good news is they've probably hit the end of the line for their legal careers on the Fourth Circuit, which is exactly where they should stay at. They should certainly not be moving up to the Supreme Court. Wilkinson, that's not an option anymore. And Judge Heitens, I'm sure, would like to get the U.S. Supreme Court. But that's not going to be happening anytime soon. Thank you, Donald Trump and J.D. Vance. The only other 2 points I want to make here is also in the discussion of that there is a precondition that you could have a presumption that conditions on the sale of firearms are perfectly fine. If you think about where that logic leads you to, basically they're saying that if Congress passed a law that said you cannot acquire a firearm or a handgun from an FFL until the age of 50, well, that, according to the arguments advanced by sort of the two anti-gun judges on the Fourth Circuit, that would be presumptively constitutional and would be perfectly fine under Heller because of that language in Heller talking about is presumptively constitutional when you're dealing with the conditions or preconditions on the sale of firearms or on the commercial activities associated with guns. Obviously, that doesn't give the government a blank check to make any condition they want up in terms of whether or not and how you buy your firearms. There has to be some limitations under the Second Amendment, which is what the Reese court said in the Fifth Circuit, but I'm pretty sure the Fourth Circuit's going to come out the other way because they're going to find a way to come out the other way just because they're never going to rule in favor of the Second Amendment. That is just the political reality of the situation. And my last point is, honestly, I said this on X. If you're not following me on X at 4Boxes Diner, you most certainly should be doing so. My only final point is this. It's pretty clear listening to this oral argument that both Judge Heitens and Judge Wilkinson, in my opinion, would be much better served and much happier if they could sit on the U.S. Senate and ask a bunch of questions and filibuster, candidates for cabinet positions like Kash Patel and Tulsi Gabbard. I think they'd be much happier filibustering and giving speeches on some Senate Judiciary Committee or whatnot, rather than sitting in Richmond, Virginia, wearing black robes. But nevertheless, that's where they are. They're in Richmond, Virginia, on the Fourth Circuit Court of Appeals. They're going to rule against the Second Amendment 2-1 is my guess. But again, it may not matter because the Reese case, as I predicted, very good chance that is the next Supreme Court case involving the Second Amendment. I've been saying that for some time, with the asterisk of we're still waiting and cheering for the court to grant cert in Snope and, of course, Ocean State Tactical, dealing with AR-15 bans, semi-automatic rifle bans, and magazine bans. But again, only time will tell as to how this plays out. But on the bottom line news, I wanted to bring you an update as to what happened in the Fourth Circuit. You need to know the good and the bad and ugly to be the smartest person in the room. And we are in a fight for our rights, our fight for our Constitution, and our fight for the right to keep and bear arms. And I'm optimistic it's all going to work out in favor of freedom in due course. So there you have it, folks. Hope you learned something here today. Make sure you follow me at 4Boxes Diner. We have almost 23,000 followers over there on X. Make sure you subscribe to both Rumble and YouTube. We're trying to get to 200,000 subscribers on YouTube, and I look forward to talking to all of you again real soon here at the 4Boxes Diner.
Orders up. Table 2A.